that's none other than Jassat.
Could you just see if I can? Yes, Mr. Peters.
My Lords, good morning. I appear for the appellant, Mr. Jassat. My learned friend, Mr. Khan, appears for the respondents, Mr. Gangat and Mr. Barwan. My Lords, if I could begin, hopefully briefly, with some housekeeping.
Yes.
You should have a core and supplemental appeals bundle and a relatively slim authorities bundle.
Yes.
You also have unagreed documents bundles from both sides, together with applications to rely on them. My unagreed bundle is very slim and contains 10 pages of documents that I do actually intend to refer to during my oral submissions, so I would ask for permission to rely on that. My learned friend's unagreed document bundle is much more extensive, but just to be clear, we do not oppose his application to rely on those documents. We did take the view and do take the view that the bundles he's produced don't comply with the practice direction, which is why we haven't agreed to their inclusion, but we regard that as a matter between him and the court.
Speaking entirely for myself, I'm not yet persuaded that there's any need to refer to large numbers of documents, but we shall see how we go. On the authorities, though, we've got, I think, 13 authorities, all of which are referred to and obviously relevant. I, for my part, haven't seen a certificate as is required. And there are lots of other authorities referred to in the scope of arguments which are not in any bundles. Once again, I'm not convinced it's necessary to actually look at them.
Well, my Lord, I have submitted a certificate to the court, but I must confess I forgot to do it when the bundles were being prepared in something of a rush, so it was submitted after the fact. Certainly all of the authorities, of which there are not a huge number, cited in my skeleton, are in the bundle. The other authorities are bundles which Mr. Khan asked to be included, having in mind the practice direction. So I am working on the assumption that he has asked to have put in the bundles those authorities in which he is most interested in referring to.
Okay, I think it's possible that in this case less is more, sort of. Can I just ask you this? Why wasn't the judge entitled to make the finding that he did about the idea? Because if he was entitled to make that finding, you're in trouble, aren't you?
Well, my Lord, I was going to deal with that ground of appeal last, but I can jump forward. In short, we say there are 2 or possibly 3 reasons why he wasn't entitled to make that finding. The first is that it wasn't, the finding being that it was an agreed statement of account. The first, which is linked to ground 2, is that his justification for making that finding is that it was a finding that he needed to make in the circumstances, and in fact he didn't. The second point, which doubtless your Lordship has in mind from my skeleton argument, is that it's a point that actually wasn't live before him, we say.
I don't see how you can say that in the light of paragraphs late 60s of your skeleton below, closing submissions, where you clearly address what is the nature of the...
Well, my Lord, there is a distinction there, and I have submissions to make about it, between the circumstances in which the document was produced, which was the issue, and whether it stands as a statement of account. The other reason that we say the judge wasn't entitled to make this finding, and it's rather illustrative of the way we do say he went beyond that which was properly before him, is that it's actually neither party's case that was an agreed statement of account. Our case on the pleadings is that it wasn't a statement of account at all, and I was going to come to this later in my submissions, but in summary, on the claimant's pleadings, it was an inaccurate statement of account.
Okay, right.
My Lord, I do also have
in that case, you make your submissions in the order that you wish, but I think, well, if you haven't covered it by the end of your submissions, you'll certainly be invited to make.
No, my Lord, absolutely, and I do have in mind. It's ground 3 of our appeal, and there are interconnections. Although it is of a slightly different character, there are interconnections, particularly with ground 2, which hopefully I will address. Yep. My Lord, just a quick point before I get into the substance of things on timetabling. My learned friend and I haven't formally agreed a timetable, but that's because we've discussed it briefly. My learned friend's view is that I should be able to open the appeal and he should be able to respond today. I will endeavour to do that. I may take a bit longer than that. There is a certain amount that I do want to go through. Of course, obviously, if I'm not helping the court, I will be moved along and quite content with that.
You will.
So, well, before I turn to the individual grounds of appeal, there is one general point, a general introductory point that I wanted to make that may be of some significance, which is that there is no respondent's notice in this case. And that may matter because what it means is that the scope of the argument before the court is whether the judge was right for the reasons that he gave. In my submission, it's not a case, if this were to become relevant, in which it would be appropriate to conclude, in effect, that the judge reached the right result for the wrong reasons. And that may have an impact on what I say, probably in reply, about some of my learned friend's submissions. So again, subject to any preferences on the part of the court, I propose to deal with the grounds of appeal in the order in which they are presented in my skeleton. So turning first to ground 1, which is document suppression. Now, my lords, this is addressed at paragraphs 13 to 30 of my skeleton argument, which is core tab 10, pages 155 to 164.
Yep.
Now, my lords, in addressing this ground, I propose to deal with matters in the following order. First, I want to address what the judge actually found in relation to document suppression. And it appears that I do need to do that because, having looked at my learned friend's skeleton, we say that the claimants haven't really, as it were, fronted up to the seriousness of what the judge did actually find. So I do want to address that. Second, I want to, hopefully at some speed, address the documents that the court had and the suppressed documents and where they fit into the overall picture, because that's an important part of the background. Third, I want to address the judge's approach and how he dealt with his own finding of document suppression and why we say the judge's approach was wrong. And then fourth and finally, I propose to deal with what we say this court should do about it.
Thank you.
So, my lord, if I could start with what did the judge actually find in relation to document suppression. Now, just by way of context, as I understand it, the following is common ground, which is from around 2006 to 2011, the claimants were embroiled in a tax investigation launched by the South African Revenue Service, which I will refer to as Sars. That as part of that investigation, they were required to provide detailed evidence about the expatriation of funds from South Africa. And that necessarily entailed evidence and disclosures as to their dealings with Mr. Jassat. Also, as part of that investigation, and as a condition of the settlement into which they entered, they were required to give full disclosure of their assets. And finally, the claimants, unsurprisingly in those circumstances, were ordered to give wide-ranging disclosure of documentation concerning their dealings with Sars. Now, my lords, the findings that we rely on in relation to document suppression are at paragraphs 19 and 20 of the judge's judgment, which is core tab 5, page 55. It's a long paragraph, and it does repay reading in full. I suspect that your lordships may have already had a chance to read this.
I think you can take it that we have read the judgment, we've read the skeletons.
Yes.
Quite how far we've chosen to follow up your references is another matter.
Well, my lord, I have references, and if they're to things you've already read, obviously I can move on. And my lord, what we say, by way of effectively a précis of paragraph 19, and particularly the second part of that, is that the judge found first that the Sars inquiry would have generated an enormous amount of documentation. Second, that Mr. Gangat's evidence that the claimants had not retained any of that documentation was not credible, i.e. that he was lying when he said that they hadn't retained that documentation. And thirdly, that Mr. Gangat was also lying when he claimed that the letter from Sars, which he claimed to have found fortuitously at the end of the first day of trial, amongst other unrelated documents, had just been found as a random search at the bottom of a box somewhere. So, in other words, inevitably that document must in fact have been, as we alleged it had been, cherry-picked from the Sars documentation that the claimants had retained and not disclosed. In other words, we say the consequences of those findings are clear. The claimants have retained, and as far as one can know, today still retain, extensive documentation concerning their dealings with Sars, which they have sought dishonestly to suppress by falsely claiming that they have not kept anything beyond which has already been disclosed. Now, Lords, even if there could be said that I'm, on the basis of paragraph 19 alone, that somehow I'm reading too much into the judgment, or there is some ambiguity in it, any such ambiguity, as we say, conclusively resolved by what happened subsequently. So we sought permission to appeal from the judge, amongst other things, on the basis that he had inadequately dealt with document suppression. This was raised expressly in our skeleton argument for the consequentials hearing, which is in the unagreed documents bundle. But perhaps this is a document I can summarise. We put the case in exactly the way I've just put it to you, in effect. We said they've got these documents, they've sat on them, and they've lied about it. And that's what we meant by document suppression. We said to the judge, you found that, but you haven't adequately considered the consequences of that finding. Now, my lords, if we had, as it were, overread the judge's judgment and drawn inferences from it that the judge didn't intend that we should draw, you might have thought that he would put us out of our misery and set us straight. But he didn't. There is and that is apparent from two documents. There is a short passage from the transcript of the consequentials hearing, which is again in our unagreed bundle. And it is perhaps worth looking at that very briefly. And that is tab 3. It's right at the back of the unagreed bundle. It's tab 3, page 11. And my lords, it's at G. Now, this was a debate about costs. I was saying that costs should be reserved because that offers had been made that the judge couldn't see and wouldn't be able to see until the end of proceedings. Mr. Khan was saying that costs should be paid now because of exceptional circumstances, including the adverse findings about my client. And then at G, what the judge says, Mr. Khan, you've got to remember that there are findings that your clients have suppressed documents. So standing there and saying that Mr. Jassat should be castigated for his conduct in circumstances where your clients have also been castigated for their conduct, I mean, how am I supposed to treat one as exceptional and the other not? So the judge clearly did think that there had been document suppression, and that is then borne out in his reasons for refusing permission to appeal, which again, I don't think we need to turn them up. It's core tab 6, page 87. But the judge's response to our application for permission on that point is that, not that, again, that we'd somehow overstated the severity of the findings that he'd made, but that he had adequately considered document suppression in the context of giving his judgment. Now, my lords, the next step in my analysis is I want to look at the significance of the suppressed document. Are
you referring to on page 87 to where he says ground one, failure to consider document suppression?
Yes.
It was considered, 16, 19, 20. Findings made that defendant assumed a position of complete control.
Yes.
And why do you take issue with that?
Well, Lord, I don't take issue with it. All I'm saying is that, I'm sorry if it's not clear where I'm going with this. From a learned friend's skeleton argument, one gets the impression that the judge's findings may be something less than that which the way I described them a few minutes ago. All I'm relying on that for now is the proposition that the judge absolutely intended to find that there was deliberate document suppression in the way I have described it. I will come back to that, and I do take issue with that in a different context, but I will make that clear when I do so. My Lords, the next point I wanted to address under this heading is the significance of the suppressed documents. And the best way to do this is to take a hopefully relatively quick trot through the documents, the very few documents that we did have in relation to the claimants' dealings with Sars. But before we begin that process, in my submission, it's important to recognise that the claimants' case throughout these proceedings was that they had been full and frank with Sars. There are lots of examples of that. I don't think I need to take you to them, but throughout it was the claimants' position that they had told Sars everything. And indeed, as we will see, that had to be their position, because the settlement, the continuing validity of the settlement upon which they relied in the proceedings, and presumably which they are keen to hang on to, depends upon them having been full and frank with Sars. So, my Lords, turning to the documents, the very few documents we did have, I want to start with a statement by Mr. Seether, one of the claimants' business partners. And that starts at supplemental tab 13, page 292. In fact, my Lords,
the affidavit of Mr.
Yes, there's an affidavit which confirms that which is behind it. So there's an affidavit at 292, and then the substantive statement starts at 293. Now this document is from May 2008, so this is already at least 2 years into the investigatory process. It's not a document that was obtained from the claimants in these proceedings. I believe it's actually a document that we produced in these proceedings, having obtained it in the Hatharani proceedings, to which the earlier proceedings involving Mr. Hatharani, to which you may have seen reference. Now, at trial, both claimants accepted that they had verified the accuracy of this statement to Sars, and the document purports to be a full and frank account, and that's apparent from paragraph 7 of the statement, which is at page 295. And my Lords, at paragraph 10 over the page at 296, it starts to describe the cash business and the expatriation of the funds from South Africa. And then, if you go over the page at 297, one of the key paragraphs is at 10.4, which sets out effectively Mr. Hatharani's control, complete control over, as it were, the expatriation of monies and therefore the Swiss end of things. And Mr. Jassat in that paragraph is treated very much as being Mr. Hatharani's man, and even if you go to page 298 at the end, towards the end of this paragraph, it says at some stage accounts were opened up which were intended to be specific accounts for each of myself, Anwar and Suru. Those are the claimants. These accounts were opened up by Jassat, but he controlled those accounts. We had no access to those accounts other than through him. And invariably, this would require the knowledge and consent of Mr. Hatharani. And then over the page at paragraph 11, there's a reference to the claimants getting, well, to Mr. Seether and the claimants getting some money out of Switzerland, but no reference to any UK assets. Paragraph 12, a reference to an inability to...
Getting money out of Switzerland. Paragraph 11 speaks of money in the foreign funds being made available to us.
Yes. Yes. And then paragraph 12 is a complaint about an inability to get an account from Mr. Hatharani as to what has been done with the monies in Switzerland. And then 13, towards the bottom of that page, says neither I nor Suru or Anwar are in a position to state what the nature of the relationship between Mr. Hatharani and Mr. Jassat is at present. We simply do not know. Mr. Jassat was Mr. Hatharani's contact person, and over the page, whether or not they remain in contact, and if so, what the nature of that contact is, we simply do not know. What we do know is that whilst we were all jointly involved in the jumbo group of companies, i.e. before the sale of the business to Rebhold, we had no independent access to Jassat. This had always been done through and with the consent of Mr. Hatharani. So, my lords, the point that we made at trial, and the point that is part of the relevant context for this appeal, is that the contents of that document are wholly inconsistent with the claimant's case in the proceedings. But of course, that document merely forms a small part of the overall documentation that one would expect to exist. The investigation had been running for 2 years, and it still had 3 years to run before settlement was reached. So, question, what further debate was had, or further disclosure about the completeness and accuracy of this description of the relationship between the claimants and Mr. Jassat? It would be remarkable if further questions were not asked about that by Sars, and if further answers were not given. And most obviously, there is one glaring question that one would expect Sars to ask, which is, well, okay, Mr. Gangat and Barwan, is Mr. Jassat holding any money for you? And if so, what?
Why would SARS ask that?
Well, my lord, we will see that when we come to the settlement. It's because, well, remember, SARS are investigating these people. They are trying to work out what they've done, but they're also working out what assets they've got. And we know that from the settlement, which I'll come to in a moment, because the settlement is predicated upon complete and wide-ranging disclosure of assets. So, and not just, as it were, assets owned in a particular way. As we'll see, the definition of assets is broad. So that is something that was squarely on the agenda. Now, my lord, the next document, which is at tab 14 of the supplemental bundle, so it's just the next tab along. Sorry, it starts at page 306.
Okay, thank you.
And my lord, this is the document, this is the letter that was produced on the morning of the second day of trial, in which the judge refused to believe had been found fortuitously. And my lords, the date of this letter is interesting. It's dated the 3rd of February 2009. So this is after the claimants received the Richmond Lodge document from Mr. Jassat, which, bearing in mind their case, was that that was an up-to-date statement of assets that he was holding for them. Now, if you go to the paragraph 6 of that letter, which is at page 307, there is a reference to a point that was being run at this time by the claimants. And it's in italicized. In paragraph, it starts, probably worth starting 3 lines down, in paragraph 4.9, where it's contended by the previous taxpayer's representative that the amounts which our client did receive did not constitute gross income in our client's hands. This is because the money was taken out of Jumbo Fordsburg, and when amounts received by our client from funds expatriated by Hatharani and or held under the control of Jassat and or Hatharani, these were funds of Jumbo, and to the extent that our client received any portion of these funds, this could only have been in the form of a dividend to our client. So what they're saying is that this money isn't, what they appear to have been saying prior to this letter, is that this expatriated money isn't ours.
Well, before that, they were saying, as the paragraph goes on, that they were entitled to 10% and it wasn't the company's money.
Yes, so they've been going, as it were, backwards and forwards on this. But of course, the really interesting thing about this is, where does this end? Because this is the last document that we have until the settlement. So what further debate is there all around this? And in particular, what are the claimants saying to Sars about their interest in the money and their assets after they have received the Richmond Lodge document? Because, of course, if they are saying, well, we don't have any assets in the UK, Mr. Jassat, as Mr. Seether had said before, if they are saying, well, Mr. Jassat is Mr. Hatharani's man, nothing to do with us, then that would be hugely significant. And my lord, then we come to the Sars settlement, which is supplemental tab 15. It starts at page 309. Now, my lord, we have Mr. Barwan's settlement. That's purely for convenience purposes. Mr. Barwan and Mr. Gangat settlement are in identical terms. It's dated May 2011. So I say it's 3 years after the Seether affidavit. It's more than 2 years after the letter we've just seen, and it's more than 2 years after the claimants have received the Richmond Lodge document. And simply from that effluxion of time, it's fairly obvious that there's been fairly extensive discussions leading up to this, about which we know nothing. Now, my lords, if you go to clause 415 of the 4.1.5, which is at page 313, it's right at the bottom. And what this says is, the taxpayer warrants that the statement of assets and liabilities as at 28th of February 2010, as provided to Sars by the taxpayer during the course of the settlement discussions, constitutes complete and accurate disclosure of all assets in which the taxpayer has a beneficial interest, whether held directly or indirectly. To the extent that Sars establishes that the taxpayer holds a beneficial interest in any asset and or entity not disclosed in the statement of assets and liabilities as provided, settlement proposal will be accepted by the Commissioner as automatically terminated. The balance of additional taxes and interest shall be payable with immediate effect, whereafter criminal prosecution shall be instituted. So, my lords, the point I make about this is that this provision, had full disclosure of what we've called the Sars documentation been given, this document creates a real risk for the claimants of them being placed in a catch-22 before the judge.
A bit like you with the Hatharani pleadings, with the Hatharani proceedings.
Well, not quite, my lord. I acknowledge the symmetry to an extent, and actually it's a point I'm going to address a bit in a moment. But not quite, because they have spent years settling a potentially enormous liability with Sars. They have a settlement agreement that provides that if they have failed to give full and accurate asset disclosure, and failed to tell Sars the full story, this settlement terminates automatically. So,
but if they're making a case here in a public trial, resulting in a public order and judgment, it's inconsistent with the disclosure that they made to the South Africans, their stuff anyway, to put it as elegantly as that.
Well, yes, but the point is this, my lord, we don't know to what extent there was an inconsistency. There appears
South African authorities do. So the jeopardy for the claimants exists anyway, doesn't it?
Well, there is some jeopardy anyway, but it creates a procedural problem for them in these proceedings, which is one can ask the question, would they say in the witness box, we acknowledge that we lied to Sars? No. They're not going to put that point to the judge, and I'm not going to put it to them. And I didn't. In fact, I cross-examined them expressly on the basis that they had told the absolute truth to Sars, and that the reason they made no reference to any arrangement with Mr. Jassat in the limited disclosures to Sars that we have is because there wasn't one.
Well, of course, that suits your client and it suits your case.
But my lord, it creates a problem, which is in that scenario, I accept I'm sort of hypothesising as to how this might have played out by reference to documents, the contents of which we don't know. But it does create a real problem for the judge, because how can he find that the claimants have lied to Sars? They're not saying they have. the allegation that they might have been hasn't even been put to them.
But at the moment, I'm not following this point. This judge had the misfortune, but it's not unique, to be confronted by two parties for whom the truth was an entirely flexible concept. Both parties, claimants and defendant, would lie when it suited them. I see, at the moment, I can't see how we can make any assumptions about what they said in the Sars documentation at all. Nor, at the moment, can I see where you go, even if they did say things. The judge clearly was capable of disbelieving or believing aspects. He was careful to work out what he believed and what he didn't. Why do you say the Sars documents are a game changer?
Well, I say they're a potential. Obviously, I accept that I am speculating because I have no option. What I do say about the Sars documents, and the stages in my analysis are as follows. First of all, the Sars documents that we have are wholly inconsistent with the claimant's case. They are very unhelpful documents. Secondly, notwithstanding that the documents we have are problematic for them, they've chosen, on the judge's findings, to dishonestly suppress other documents. Now, it is a legitimate inference, indeed it's an almost inescapable inference, that they wouldn't have done that unless whatever they are sitting on, contents of which we don't know, was even worse. And there are two limbs to that. The first limb is that parties tend not to hide documents and run the risk of being caught hiding documents unless they have a good reason to do so. But also, given the documents we do have, the risk of getting caught out was particularly high, because what we have is we have documents that clearly indicate the existence of lots of other documents. So document suppression was an extraordinarily risky thing to do, and there must be some reason why they did it. And so, you're right, my lord, I cannot give you specifics as to what the suppressed documents might or might not have said. But in some ways, that's not really a point that can fairly be taken against me. That's why document suppression is so serious, because it leaves a litigant in my client's position and counsel in my position saying, well, we don't know what we don't know. But all we do know is that something has been dishonestly and deliberately kept from the court. So, my lord, the headline point I make, having briefly looked at the documents we do have and what you can perhaps say about the documents we don't, is that if one is asking in a general sense, how serious is this document suppression and how potentially corrosive is it of the overall process, the answer is very. And well, the next stage in my analysis is to address the judge's approach and why we say the judge was wrong. So the first issue that arises is, what did the judge actually do with his finding of document suppression? And we say the answer is very little of sufficient substance. And this is where I do want to go back to the reasons for refusing permission to appeal. So that's core tab 6, page 87. And well, it says failure at the top of the page, ground 1, which corresponds with the ground 1 before your lordships. Failure to consider document suppression by Cs. It was considered, see paragraphs 16, 19, and 20. Now, 19 and 20 are the well, 19 is the long paragraph I showed you earlier that makes the finding of document suppression as against Mr. Gangat. 20, albeit in shorter terms, makes an equivalent finding as against Mr. Barwan. And all that leaves is 16 of the judgment, which is at core bundle, tab 5, page 54. Now, this is the judge talking about the general issues in relation to documents. Documents, now bear in mind, first of all, sorry, my lords, this is actually, in the judgment, this is before the judge makes his finding of document suppression. And his only reference in 16 is the last sentence, where he says, this is a particular danger where it has been said there has been deliberate suppression of relevant documents by one side or the other in a case.
Well, we've read the whole of that paragraph.
Yes.
And that's your point, isn't it?
Yeah.
Documentation is not complete, which is a danger that the picture that's disclosed is misleading, the particular danger when it's been deliberate suppression. What's wrong with that?
Well, there's nothing wrong with that as a starting point. The question, the point that I make, and I accept it's very much the foundation of this ground of appeal, is that enough? And we say it isn't.
Why not?
Well, for the reasons that I give in my skeleton and for reasons that I'm about to develop before your lordship. What we say in summary is that where, given the seriousness of document suppression, given the extent to which it risks distorting the court's ability to do the court's job, and that's against the context that's doubtless very well known to your lordships, which is that contemporaneous documents are key. But where the court has made a finding that serious, it does need to expressly address what the impact of that finding actually is.
I'm just wondering, that's all very well as a general principle, but you've just made the point that contemporaneous documents are key.
Yes.
These are documents that post-date the events, and they would need to shed some different light on the RDL, which was a contemporaneous document, on which the judge did rely.
Well, sorry, my lord, I think we need to be quite careful. So these are, in one sense, the RDL is not a contemporaneous document. It is on the pleaded case, is a document produced decades after the event that reflects that which happens earlier.
Well, it reflects some dealings of some kind. Everyone agrees that it reflects some sort of dealings and agreements and discussions.
Yes, my lord, I accept
that took place on the date that it was made. What's being said to Sars is the state of play in 2010, true and fair view of the assets and liabilities of the taxpayers in 2010.
But bear in mind, my lord, the Sars documentation runs, as it were, contemporaneously with the Richmond Lodge document, in that disclosure of assets is being given at the same time as the run-up to the production of that document and the aftermath of it. So, had the documents not been suppressed, one would be able to sit the Richmond Lodge document right next to what they were saying to Sars immediately thereafter. And that is
what I'm trying to get at is what, in engaging what you candidly accept has to be speculation, given that you don't have the document.
Yes.
What is your speculation as to what support the missing documents might give to your client's case?
Well,
that the RDL was, for instance, largely dictated to him for some reason in order to mislead Sars.
Well,
I'm just struggling to understand that.
Well, there are lots of possibilities. The most stark one would be if there were discussions in, say, February 2009, so a month after, well, let's say March 2009.
But your case is perfectly simple. The picture that we have may be misleading because of the suppression of documents. And that's all you can say, isn't it? I mean, you can give my lord 45 different things that the documents could say, but you come back to the point, you don't know what they say.
Yes. But my lord, I do say this, and it's the point I made in my skeleton, which I submit is quite an important, it's actually a point of principle, which is I accept the proposition that judges, day in, day out, have gaps in the evidence before them. The evidence is never complete in any case, and so the extrapolating across evidential gaps is part and parcel of what judges do all the time. That I accept, and that I have to accept. But I do say that where you have deliberate document suppression, it gives rise to what I've called qualitatively different concerns. Because it's not just the picture is incomplete, it's a gap in the picture has been deliberately created by one party. So, my lord, take what maybe we'll see if it works as an analogy. Often a trial is like a jigsaw with missing pieces. And you may have a jigsaw picture of an animal, and you're missing the tail and you're missing a foot, but you say, well, I can see the trunk, I can see the ears, I can see the tusks, it's an elephant. And there's no problem with that. Where you have document suppression, what is removed is something that might or might not completely change what the overall picture looks like. To take an example, if you have an analogy, if you have a sentence saying proposition Y and then a blank, true, the blank could be is, could be isn't, could be was, wasn't, will be, won't be. And all you know for sure, well, you don't know what's under that blanking out. All you know is that it has been deliberately created at the instigation of one party.
What would be the most helpful documents that have been suppressed from your point of view? What might they have said which would help your case?
If, after having been given the Richmond Lodge document, there was a debate with Sars along the following lines, which is, look, Mr. Hatharani has said that Mr. Jassat has made all sorts of investments for him in the UK. What we want to know is, is there an analogous arrangement or anything like it between you and Mr. Hatharani? And if the answer was, this is after the point at which they have the Richmond Lodge document in hand, no, absolutely not. We are at the mercy of Mr. Hatharani. Mr. Jassat is his man, in effect what was said in the Seether affidavit, but said at a time when they have got the Richmond Lodge document. That would put that document in a fundamentally different light, I say. And, my lord, I do think it is worth, just when one is considering the impact of this on the judge's reasoning, to look at where he dealt with documentation. Because there is a section in his judgment dealing with documentation. It's paragraphs 23 to 26. First point, no reference there to document suppression. Notwithstanding that it follows hard on the heels of the finding of document suppression.
You wouldn't expect it, because he says the principal sources of documentation available at trial.
Yes.
He's already dealt with the suppression of documents.
But, my lord, the point I wanted to make is that quite a lot of this section is devoted to a document that you'll have seen referred to as the Grant-Thornton report. In effect, it's a report that my client produced to HMRC via Grant-Thornton, which set out an account of his dealings and which was inconsistent with his evidence in this case. And the judge clearly regarded that as significant, and one can understand why he did. But there is something quite striking about that, my lord, when one thinks about it, which is that what's happened in this case is that Mr. Jassat has his hands on a report produced to the UK tax authorities, which is unhelpful to his case. And what he has done, as he should, is he's disclosed it. And the judge, having had it, regards it as highly significant, and it has shaped the analysis that follows to a significant degree. However, on the claimant's side, there is an indeterminate mass of equivalent documentation which has been dishonestly suppressed, and which frankly would or might, and indeed one would expect to point in precisely the opposite direction. So the obvious question arises, well, if the Grant-Thornton report stands in isolation, and you can understand why, if that's all you had, you might place a lot of reliance on it. But the judge knows that there may well be, as it were, an analogue of the Grant-Thornton report, or a series of documents.
It's not an analogue. It's just another document which has not been disclosed, or documentation which has not been disclosed.
But my lord, my point is this, which is that the Grant-Thornton report is treated by the judge of having a very high degree of significance.
Because one knows what's in it.
Yes. But what one knows is that communications of a very similar genus, if I can put it that way, have been suppressed. And so you have this very lopsided documentary picture. And the problem is, it's very difficult to cure that lopsidedness where the gap arises not from documents being lost or the vicissitudes of circumstance, but from the gap being deliberately created by a litigant.
So is it your submission that as a matter of principle the judge was not entitled to find for the claimants given that suppression? Or is it your submission that he gave some weight but inadequate weight and that we should reassess the weight to be given to evidence, or what?
My submission is twofold. First of all, that in principle the judge was required separately and expressly to analyse the potential significance of the suppressed documents. That there should have been, in effect, a section of his judgment saying, this is what these documents are, this is why they matter, and this is what the consequences of that are. My point is that it is a sufficiently serious matter in terms of the overall shape of the evidence that it is not enough for the judge to make the finding, not discuss the significance of the suppressed documents at all, and then have a very brief statement, actually earlier in his judgment, saying, I have in mind that there are allegations of document suppression, which is effectively all he said, paragraph 16.
Thank you.
So that is, but there is a second error, and it's identified in my skeleton, which is, of course, one doesn't know exactly what the judge thought. One doesn't have full particulars of what the judge thought the relevance of the suppressed documents was, because his judgment doesn't analyse that question at all. However, we do have, and here I go back to the reasons for permission to appeal being refused, which is page 87, tab 6, page 87 of the core bundle. And it's the second sentence of the reason, which I read as the judge's justification for, further justification for his conclusion in relation to document suppression. It says, findings that the defendant assumed a position of complete control over the assets and only he knew what had become of them. Now, my lords, we do say that tends to indicate, I accept it's a brief statement of reasons, but it tends to indicate that at best, the judge's assessment of why the suppressed documents mattered was incomplete. Because the point was made expressly that the Sars documents were relevant because they would tell you what the claimants were saying about their relationship with Mr. Jassat, and that if what they were telling Sars was inconsistent with their case in these proceedings, that obviously that would be very harmful.
But your Scanners argument tells us that you want us to conclude that the judge was bound to dismiss the claim because he should have found that the suppression had put him in a position where he couldn't barely do otherwise.
That's the second. So my argument proceeds in two stages, my lords. The first is I identify errors in approach, and I say I've identified two. And then the question is, well, if I'm right about this, if the judge has erred in approach, what should this court do about it? And that will depend on a number of things, including the seriousness of the error. The problem is, if I am right that the judge was in effect duty-bound at least to consider these points expressly and thoroughly in his judgment, then his failure to do so does rather strike at the whole fact-finding exercise. Because what he's done is he's judged the case by reference effectively to a distorted playing field, and he hasn't analysed how that distortion, if it can be corrected, is to be corrected. If he thought that the relevance of the Sars documentation was only to do with Mr. Jassat's control over monies in Switzerland, then again he's made a fundamental error. He's actually then judged the evidential landscape by reference to what we would say is a misunderstanding of the picture. Now, if we're right about that, then this court can and should...
Sorry, I'm being a bit slow. what is the misunderstanding of the picture? What the judge says in his, admittedly, very brief reasons.
Yes.
I found, and implicitly, I had sufficient material, despite all the deficiencies on both sides of people
Yes.
denying, suppressing documents, generally not assisting the court, but trying to protect their own interests. I found Mr. Jassat had control of the claimant's assets. That's all he needs to find in order to order an account. So why is that not a reason for the judge to say, I had all sorts of problems because of the way both people refused to engage as they should properly have done with the litigation process. But what I did have was sufficient to enable me to make this finding, that the defendant assumed a position of complete control over the assets.
Yes,
And as long as you add to that, and I'm satisfied that they were the claimant's assets, that's sufficient to order an account. And that's all he's done. He's just asked for an account to be given.
My Lord, I think actually that is a fair point, and I think I may have overread that second sentence. I was treating that as a statement as to what the relevance or potential relevance of the suppressed documents was. I think your Lordship's point is it's a more fundamental matter, which is it's saying, look, I've made the findings I need to make anyway, so suppression doesn't matter. In which case, if that's right, there wouldn't be two errors. I would have to stand on the first error that I identified.
You effectively have to say that in a case where he has found document suppression, the only possible reaction would be to say, I'm not going to proceed to make any findings of fact because I don't feel I can safely do it. That's effectively what.
Well, all I said. Well, at the moment, I make a less ambitious submission than that. What I'm saying is that the judge has to, because the problem with saying, well, I've made the findings I need to make, and that's the end of it, is that there is a circularity built into that, because the effect of the document suppression, if I'm right in what I've said, it comes in an earlier stage. It actually poisons his ability to do precisely that. Now, what I say is that there may be multiple ways that a judge could deal with that. The judge could have said, I think that the relevance of these documents is X, Y, and Z. It has the following impacts on my ability to make findings. He could have said, but I don't care because I can cut through. Ultimately, the documentary evidence one way is so strong that I can cut through and make the findings. He could say, this is difficult. I need to proceed by way of adverse inferences or burden of proof, and how does that affect the overall picture? Or he could say, I can't decide the case because I've got such a distorted picture. All of those options would be open to the judge. I think I have to accept that you cannot say a finding of document suppression mandates inevitably a particular conclusion, because the significance of the document suppression will... Sorry, there's a sort of feedback on the... I was hearing myself. It was slightly distressing.
Does this mean we are having a transcript?
Yes, I give authorised it.
Right.
At the party's expense.
It's helpful to know. Thank you.
Actually, I'm sorry, just pausing there for 1 second. My understanding is in this court we don't normally have a break for shorthand writers, but I'm in the court's hands as to whether you accept it. No, it's a...
Well, you're not shorthand writing.
No, sorry, it's a...
So, unless the gentleman says you're going to need a 5-minute break.
I'm okay.
You're okay, fine. We'll plow on
We'll crack on then.
with all the benefits of a transcript.
My lords, the point I was making is that I accept that there may be, where document suppression is found, there may be multiple courses open to the court. But which of those is the correct one is necessarily predicated on an analysis of what the suppressed documents are and why they may matter. And so what the court is bound to do is at least go through that first stage. Because if it doesn't, there is a risk of it, and indeed a probability of it, deciding the case by reference to a distorted playing field that has not been undistorted by any reasoning in the judgment. So I don't go as far as to say the judge will always be duty-bound to effectively strike out or to dismiss the claim. But there is an earlier stage. The judge has to analyse why may this matter, and how does that affect my ability to decide the case fairly, at all, in a particular way. As I say, those questions flow from a prior analysis that does have to be, and we say has to be expressly conducted.
But it must all depend on the facts of the particular case. In a case like this, if the defendant, when in the witness box, admitted under cross-examination that he was holding assets for the claimants, that would be the end of the case.
Yes, but
So it wouldn't matter how many documents the claimants have destroyed or suppressed, because you've got a plain admission on the face of a transcript, and that's enough to give judgment. Now, obviously, we're not quite in that position here, but the judge did have your client in the witness box. He did have what your client had said in the previous proceedings and the inconsistency between them. Of course, it might have assisted him to know what the claimants were saying about that at an earlier stage, but he might have thought, I've got sufficient material to make a finding of fact on the balance of probabilities which I'm comfortable with. And it doesn't seem to me one can be at all prescriptive about how a judge has to deal with a finding of document suppression in any particular case. It must all depend on the other evidence in the case and the effect. Well, you yourself have said of the missing documents might have had on the findings of fact he's being asked to make.
Well, I'm not sure I disagree with most of that. It's the point is, what does the judge have to do, if anything, and is it sufficient to find that there's been document suppression and say, well, I've got it in mind, and stop?
Well, he did a bit more than that. Don't you have to say that 16 and 17 read together are wholly inadequate? Because having said what we looked at earlier, at the end of paragraph 16, he goes on to say, to acknowledge these as challenges, and to say what he's going to set out to do, which is to do his best.
Well, I think that's fair. I do have to say that that's inadequate, and I do say it's inadequate. And the way I put it in my skeleton, which effectively remains the submission I'm making to your lordships, is that it's not enough to just, as it were, throw it generically into the pot. And I do say that it's document suppression, as it were, on spec is serious enough that proposition can be stated generally, but it's particularly so here. And there are two limbs to that. The first that I've already addressed you on, namely the potential relevance of the suppressed documents. But there is another aspect to this, which I've again raised in my skeleton, which is that this is a very unusual case. The judge found, well, there was virtually no contemporaneous documents, in part because the claimants had been averse to keeping certain categories of contemporaneous documents. The judge was very sceptical about the credibility of all of the witnesses. And that's why, for example, he ends up having to rely so heavily on a document like the Grant-Thornton report. And then that comes back to the point I made earlier, which is there is a real danger of distortion where you have, or you may have, equivalent documentation saying goodness knows what from the claimants that has been suppressed.
But they're different. Your hypothetical documents passing between the claimants and Sars, I mean, we know there were documents.
Yes.
The kinds of documents that might have existed are of a different character from the Grant-Thornton document, are they not? Because the key bits of the Grant-Thornton document are, in effect, admissions against interest on the part of your client, whereas what we're thinking of might appear in the Sars documentation are lies, or statements that are defensible, that are advantageous to the claimant's position. They're lies on the judge's finding. They're statements advantageous to the claimant's position vis-à-vis Sars.
I can see that, but that for reasons I think I've already given, my lord.
Self-serving, I think, is what I'm groping for.
I see that point, my lord. It's a fair point, but it does cut both ways for reasons that I think I'm not going to repeat myself, but essentially because of the bind the claimants are in via the Sars settlement and the consequences of their disclosure to Sars not being full and frank.
So if we conclude that the judge has not given adequate reasons,
yes,
what do we do?
Well, it seems
Set
to me.
aside judgment, order a retrial,
Ask
Well-
him for reasons.
ask him for reasons.
Well, our position would be that at that point, you have to consider it effectively with a relatively clear playing field, and those are all options.
Well, no, what are you asking us to do?
Our position would be that the appeal should be allowed and the claim should be dismissed. And we do.
That's effectively substituting our own discretion for the discretion which the trial judge had, but you say never really exercised.
Yeah, in circumstances where obviously this all proceeds on the basis that you are with me as
Yeah,
far as the judge being wrong. If the judge's approach is wrong, in my submission, it would follow that this is sufficiently significant that it does rather undermine his fact-finding.
When you say
exercise.
wrong, I think what you're saying is that he's given insufficient reasons.
Well, I think that's the reason I hesitate, my lord, and I'm not trying to be cute about this. Is the judge has said what his reasoning was in his. So it's not a case that the analysis has been done but hasn't been explained sufficiently. It may be that the analysis has not been done at all.
Can I ask you this? Did you invite him in your closing submissions not only to find document suppression, which I think you clearly did, but as a result to conclude that it was impossible to have a fair trial
No,
and dismiss the action?
I have to accept that we didn't put the point in that way. So I cannot say that the judge was wrong to.
It's quite difficult to criticise the judge for not dealing with something he's not been asked to deal with.
Well, my lord, that's why I developed the argument in two stages, which is the error is not the error that I rely on is not an error in the form of a failure just to strike out the action or do something equivalent to a strikeout. And I accept I would be.
But that is what you're asking us to do.
That's what I'm asking you to do. I'm saying the judge.
Okay, well let me go back. How can you complain that we ought to dismiss the action if you didn't, because the judge didn't dismiss the action, if you didn't ask the judge to dismiss the action?
Because
I mean, judges have a difficult enough task, especially in cases when people lie to them, about having to research the law for themselves and think of points for themselves. Judges respond to points that are put before them.
Well,
What was put before this judge, as I read your closing submissions, is I invite you to make a finding of document suppression, which you duly did, and I invite you to take that into account as part of the material in reaching his findings of fact, which is what the judge did. There's not a, unless I've missed it, a section saying, if you are with me and you find document suppression, then you have to separately consider how that affects the handling of the trial, and you have a menu of options, starting with dismissing the action and ending up with ignoring it. It's not there, and if it's not there, how can you criticise the judge for not doing it?
well, so the point is raised, and the relevance of the documents was raised with the judge. So I
Which
say,
point is raised?
well, sorry.
What
Sorry,
point is raised?
quite right, my lord. The point about there being document suppression and the relevance of the Sars documents and their importance, those points were all squarely in play.
No.
And that is why, and I do say that means that I can make before this court the point that the judge made the error that I allege him to have made, which is that the judge didn't adequately consider those points. I don't go further and say that the judge erred in not striking out the action, because as my lordship quite rightly points out, he wasn't asked to. And so I have to take that on the chin. What I say is that the judge made the error I've identified, which was a prior error, and that to an extent, opens up if you're with me on that opens up the field of play.
It's the same thing. In fact, it's worse because you're trying to elevate a lesser point to take the place of the bigger point that you know you can't take.
Well, my lord, anyway, that's the way I structure it. I think I've made my submissions as to what I say the judge's error was, and as to what you should do about it. Obviously, if you're with me on the error, then the court has to do something. Obviously, and we are pitching for you should dismiss the claim. But if you're not prepared to go that far, then questions such as
And in what circumstances is it appropriate for a court to dismiss a claim where it's satisfied that someone has deliberately suppressed documents? Because you accept it doesn't automatically follow. Is it to penalise the claimant? Or?
no, I think it would have to be because it's effectively for the reason of principle that I identified earlier, because the court has to look at how badly distorted the whole playing field is.
Is it a bit like the principle that if somebody is an obvious witness and is not called, and there's no reason why they've not been called, you can presume that their evidence would have been unhelpful?
Yes, it's more than that, of course. But
it is more than that, because I'm not aware that you can dismiss a claimant's claim because they haven't called an obvious witness. What you can do is say, I'm going to draw the inference that that witness's evidence would have been unhelpful, and I'll put that into the mix when reaching conclusions. But you, I think, go further and say, if you're in breach of your disclosure obligations, dishonestly suppressing documents, that entitles and sometimes obliges the court to say, well, you can't bring your claim at all. Doesn't matter what I think the facts are otherwise. I'm simply not going to proceed.
Well, I think there are in my skeleton I've identified three possible routes. One is the strikeout, and I think I accept that the authorities make clear that strikeout during or after trial is almost never appropriate. But mostly because the court has other things that it can do to fit. It's got a much wider range of tools once it's at trial. The two perhaps more promising candidates are inferences and burden of proof, because here you have the claimants bearing the burden of proving their case. They have suppressed documents of potentially critical relevance to that case. And then, of course, you get into the circumstances more generally, which is that they have suppressed documents that are potentially critical to their case. The judge has not been impressed with their credibility as witnesses. And you put that in the mix, and then you can end up saying, well, do I think the claimants have done enough?
But once you're into that territory, the assessment of where, on the balance of probabilities, the truth lies, bearing in mind the onus is on the claimants, then it's very difficult for us to substitute our view for the judge's view.
I'm to an extent in your lordship's hands on that. I accept that.
It does look like a case where you're going to have to sort of concede that what you're asking for is a retrial. That was striking me, because if we can't make the decision, you say the judge has fallen short of what he should have done, then the logical consequence is a retrial.
I see that, Lord.
Based on a new point.
I see that.
And that's a problematic position to be in.
Yes, it's a as I said, the steps in my argument are that the judge has made an error. This court has to do something about it. The something could include simply dismissing the claim. I see your lordship's point about why that's difficult. The alternative something is to order a retrial, and I can see that. There is a problem though with a retrial, which is this question of suppressed documents is going to rear its head again, and it's quite difficult to see how it's going to.
But it goes further, because you're into it. You're on a point which you didn't raise below. Normally, this court won't allow you to take points that weren't taken below if they would have had a structural difference. And what you're submitting now is that the structural difference would have been so great that you've got to have a retrial. To my mind, that calls into question whether you can take this point at all.
Well, the reason I say I can take it is because of the error I accuse the judge of making is one that was an error in the way he approached that which was before him. I don't say that the judge erred in not striking out, if that makes sense. And I can't say that, and I accept that I can't say that.
If I understood the error you identified correctly, which is that he was obliged, in order to properly assess the significance of the document suppression, to have a separate section of his judgment addressing what might have been in those documents and what effect the omission of those documents, the fact they've been deliberately concealed from him, has on his fact-finding ability. Is that
broadly? Yes, my lord. That's right. And I think that I do say that But there's nothing. Well, sorry. Let me go back a step. I can't cite any authority that says
No.
has to do that.
I understand that. I mean, it is. One has to be careful about this court telling judges what they have to put in their judgments, because judgments just get longer and longer. And there is long-standing authority that judges on the whole are to be trusted to know what they ought to do, and just because a judge doesn't mention a point in his judgment, it doesn't mean that he hasn't taken it into account. Again, I mean, without wishing to be at all critical, I don't see in your closing submissions a bit saying, if you are with me that there is document suppression, then you need to analyse what effect that has on the case.
Well, except of course the point was made, and it was made repeatedly to the judge, that the Sars documentation is of critical relevance, and that you should proceed on the basis that the claimants are telling the truth to Sars because they say they are. And
I think the judge proceeds on the basis that nobody ever told the truth, and unless they thought that.
Well, yes, except it is slightly different where it's common ground that the parties are telling the truth about a particular.
Well, just because they
Common ground that your client didn't tell the truth. I mean, my Lord's point is, and speaking for myself, I think this emerges clearly from the judgment. He didn't think either side's evidence was to be trusted.
No.
So he looked for something reliable, things that were reliable, and he set out the things that he thought were reliable, and made a judgment on the basis of things that were reliable, rather than what the lying parties told him.
I entirely understand that if you had a case in which a judge had said, I find this witness to be a credible witness, and then finds that that witness has dishonestly suppressed documents, you could say, well, you really can't do that because he doesn't know what inconsistent statements that witness might have said.
Yes.
But in this case, where he finds that claimants are unreliable, well, are liars, and your client is a liar, and has indeed purged himself either in these proceedings or the previous proceedings, the judge is in one of those very difficult positions where he just has to pick his way through looking for what secure footholds there are in this swamp of dishonest statements. And that's what, to my mind, the judge has tried to do. Now, you may say he's got that wrong. I think you do say he's got that wrong. But I think it's quite difficult to accuse the judge of failing to appreciate that claimants were dishonest. I think he appreciated fully that both the claimants and your client were dishonest, and he just had to do the best he could with the material he had.
Well, my lord, I see that point, but again, it does cut both ways, at least to some extent, because it's actually a point I make in my skeleton, which is that it's one of the reasons the document suppression is so unusually serious in this case, because the judge is having to navigate.
It's what lying parties do every day of the week. I'm afraid to say, Mr. Peters, that you speak of this being an extraordinary case. In the experience of this court, in various different divisions, this is not extraordinary. This is common or garden lying parties who are trying to protect their interests, and they therefore inevitably say inconsistent things from time to time, depending on what suits them.
Well, if I can just be clear, my lord, what I say is quite unusual. I accept that to an extent, but actually for the court to go as far as to find that documents have been deliberately suppressed is extremely unusual.
No.
In my submission.
No. Not mine. My experience, I may just come from a more roughy-tufty end of the spectrum than you do, Mr. Peters, but in my experience, no.
Well, my lord, I'm not going to, as it were, try to match experience.
We're not going to compare the state of our practices, but at the moment you've got some persuading to do if you want to go on, but I think I have your point.
My lord, I think probably on ground one I've said all I can say.
Yeah.
So I was going to move on to ground two,
Yep.
breach of fiduciary duty. This is addressed at paragraphs 31 to 47 of my appeal skeleton, which is core 10, 164 to 173. Now, again, just by way of structure, I propose to deal with matters in the following order. First, I'm going to address the relevant legal principles. Second, I want to go through with some care the claimant's pleaded case to identify what the claimant's claim is actually and was actually for. And then, thirdly, I'm going to address the judge's reasoning and the ways in which we say it was wrong. So, my lords, first of all, on the legal principles, I can deal with this actually quite shortly and by reference to the judgment, So if we perhaps could take the judgment, it's core tab 5, starting at paragraph 115, which is page 82. Okay. So, my lord, paragraph 115, first of all, rejects any trust-based claim, essentially because of a judge's conclusion that no relevant property was actually vested in Mr. Jassat himself. Then at 116, he refers to the alternative claim for breach of fiduciary duty. At 117, he cites Al-Dwayson. And then the 118, he expresses what we say is effectively his conclusion on the law, which says, in other words, where A has control of property belonging to B, in circumstances where viewed objectively, B is entitled to expect A to administer that property for the benefit of B, then equity enforces A's obligation of due administration by requiring A to account for his dealings with B's property. And, my lords, broadly, we are content with that formulation of the legal principles. So if one just breaks it down in terms of what the requirements are, there must be property. It must be property belonging to the principal, and the fiduciary must be given control of that property such that he receives it in an accountable capacity. Or, as the judge put it, the property must be placed under the fiduciary's control in circumstances where, viewed objectively, the principal is entitled to expect the fiduciary to administer that property for the principal. What we say is that the judge's errors, which I will come to after I've looked at the pleaded case, wasn't in identifying those as the key legal tests. It was in how he applied those on the facts that he found. So, my lords, the second part of this bit of my submissions is, what is the claimant's case? Because there's an obvious introductory point, which is that it is the case pleaded in the amended particulars of claim, and only that case, which was properly before the judge at all, and it wasn't open to him to determine the claimant's claim in their favour by reference to some other different case. Now, my lords, probably the best way to begin with the amended particulars of claim is actually to start with the breach of fiduciary duty claim, which is quite a long way through, and then jump back. So if you could go to Core Bundle, tab 7, page 115. And paragraph 35, what is said is, further or in the alternative, by reasons of the matters referred to above, namely that he was appointed an express trustee and or his dealings with the claimants, which gave rise to a relationship of complete trust and confidence with the claimants, it is averred that the defendant owed the claimants the following fiduciary duties. And there you have listed a fairly standard set of fiduciary duties. Now, my lord, the point I make about 35 is, of course, 35 does not contain within its four corners, as it were, a complete case of breach of fiduciary duty. There's nothing wrong with that. I don't complain about that at all. But the significance of the breach of fiduciary duty is that it is effectively an alternative analysis of what flows from the facts that have been pleaded in relation to the trust claims. Now, presumably it's there to make sure all bases are covered, including a situation, which is what the judge has found to have occurred, in which Mr. Jassat obtained control over what the claimants alleged to be the trust fund, but did not obtain title to that fund. So in other words, it's filling a potential gap in the legal consequences of the facts pleaded. So in order to identify the facts that support this breach of fiduciary duty claim, you have to go back and look at the primary trust claim. So for those purposes, I want to start at paragraph 9, which is on page 95. And it says, paragraph 9, prior to 1982, in or around 1980, approximately 4 million belonging to the claimants were expatriated from South Africa and placed into an account belonging to the claimants, named B. Kidney and or Tyson, held in the multi-commercial bank in Geneva, Switzerland, later known as Bank Safdie. Now, just pausing there, because this is maybe quite important. As at that point, this is obviously pleading a narrative, as at that point in the narrative, is there any duty to account to the respondents on the part of Mr. Jassat in respect of this money? Now, the answer on the pleaded case is no, and that's apparent from paragraph 10, because it makes clear that the claimants were not even introduced to Mr. Jassat until after this money had arrived into Switzerland. Go over the page at 96 to 11, paragraphs 11 and 12. It says, the defendant introduced them, which is the claimants, to Mr. George Deville, an account manager in Switzerland, with whom the defendant had dealings with through Mr. Hatharani. As a result, prior to 1982, the claimants transferred 4 million of their monies from their B Kidney and or Tyson account to the defendant's account called Camelot. So here, my lords, actually you have a factual averment that potentially falls quite neatly within the legal framework identified by the judge. You have the claimants transferring or alleging that they've transferred a specific sum of money from an account which they say is theirs to an account which they say is Mr. Jassat's, thereby placing the money under his control. And then at paragraph 12, you have the allegation that that payment gives rise to a bare trust. Now, on the same page, if you go down to paragraph 14, this pleads, as it were, the trust agreement. And I think for the purposes both of the cases it was argued at trial and indeed the judge's conclusions on breach of fiduciary duty, this is probably the key paragraph. So 14, as a result, in 1982, with the defendant's express oral consent, the claimants appointed the defendant a trustee of the following trust fund. First, subpara 1, over the page at 97. The 4 million belonging to the claimants held by the defendant in the Camelot account. So that just carries this forward. 2, money transferred from time to time by the claimants to the defendant so as to be under the control of the defendant and accepted by the defendant as an addition to the trust fund. Just pausing there, my lords, what one would expect to see later in the particulars of the claim, and what one does see, albeit only to a very limited extent, is the particulars of the claim then going on to identify further sums which have actually been placed with Mr. Jassat pursuant to this paragraph.
Well, unless you're asking for an account because you don't know what's gone where.
Well, my lord, I'm coming to that.
And I'm only dealing with the submission you've just made.
Well, no, this comes in at an earlier point, my lord, because remember, the duty to account, in order for there to be a duty to account, it has to relate to particular property. So in order for there to be a duty to account, and as I said, this is the legal test the judge set himself, property has to be placed under the control of the alleged fiduciary, and the duty to account attaches to that property. So what a principal can say is, I have placed my painting X amount of money, or even an unknown amount of money into this bank account with you, and I want to know what you have done with it. But that is different from a scenario in which the claimant comes to court saying, I think I might have placed some property with you, but I don't know what it is, and I want you to tell me what it is, and then give me an account of what you've done with it. That is, in my submission, not an acceptable way to pursue this sort of claim.
Suppose a claimant comes to court and says, I'm quite sure I have, over the years, given you control of all sorts of financial assets. I can't tell you what they are, but you ought to know. And you go into the witness box and says, yes, I agree. I have received a whole lot of money for the claimants. But I can't tell you now what it is or what's happened to it. Surely the judge can order an account in those circumstances.
Well, possibly, my lord. The reason I hesitate is that is not this case. It's why I'm going through the particulars of claim quite carefully, because the first question is always going to be, what is actually alleged by the claimants? What are the claimants coming to court saying? Because you have to test what follows by reference to that. So, my lord, I'm sorry if your lordship feels I'm not answering your question.
No.
Can I perhaps go through this?
Yep.
And then I think the questions may become more specific, if that makes sense. So, and then 3. So we're page 97. 3. Investments or properties purchased by or transferred to the defendant using the claimant's monies so as to be under the control of the defendant. Now, just pausing there, what are the claimant's monies? Well, at this stage in the pleading, as we go through it chronologically, that can only be a reference to the 4 million plus any money that is subsequently placed with Mr. Jassat in accordance with subparagraph 2. Now, paragraph 15 then sets out the terms of the trust agreement in more detail. So the defendant was appointed a trustee of the above trust fund pursuant to the following express terms, which were agreed orally between the defendant and the claimants in 1982 as follows. 1. The defendant shall hold the 4 million in the Camelot account, and any further sums in addition to the said 4 million transferred by the claimants to the defendant on trust for the claimants absolutely. Sub 2 allows the 4 million and any further sums, if there are any, to be invested, but only on written authorization. Sub 3 is quite interesting because it then gives some flesh on the bones of how money is to be placed with Mr. Jassat, because it says the claimants will pay money into the defendant's Cold Star and Pitman accounts held at the bank Multi-Commercial, later known as Swiss Bank Safety. And the defendant would ensure that the monies so transferred belonging to the claimants were kept secure and used only for the benefit of the claimants. And then 4 follows on, over the page at 98, follows on from what is said before, which is that the claimant will effectively keep the money safe. 5 sets out the basis on which the defendant will hold properties purchased as a result of the claimant's monies. And again, the short point there is, well, what are the claimant's monies? And it's the 4 million plus any other monies that are alleged to have been paid to the defendant. And then 6 is the obligation to effectively to account. Paragraph 16 and 17 on page 98 assert the existence of an express or special trust and a duty to account. Paragraph 18 concerns an alleged loan of 1 million, which I think is by the by for present purposes. It's referred to briefly by the judge right at the end of his judgment, but it's not as it were in play for the purposes of this appeal one way or the other. And that brings us to paragraph 19. Between 1996 to 1997, the claimants jointly transferred to the defendant is supposed to be various sums of money totaling approximately in excess of 8 million, namely 12 million, 2.4 million of which belong to the claimants. And the remainder of the monies either belong to Mr. Hatharani and or Mr. Dinesh Sita. These monies were transferred from the claimants' B. Kidney and or Tyson accounts in Switzerland to the defendants' Bank Multi-Commercial, Cold Star and Pitman accounts. It is averred that these monies were transferred from the claimants' B. Kidney and or Tyson accounts by the defendant on the express authority and instruction of the claimants. Upon transfer, the 2.4 million belonging to the claimants became subject to the aforementioned trust referred to in paragraphs 13 to 60 above. So again, this is a rubric that falls broadly within, if proven, falls within the breach of fiduciary rubric the judge adopted. It's a payment by the claimants to the defendant in a manner which is in accordance with the agreements that I've shown you that are pleaded above. My lord, the last bit of that paragraph which I read out is significant in a different way. It says, upon transfer, the 2.4 million became subject to the aforementioned trust. So just pausing there, a relevant question is Mr. Jassat alleged to be subject to a duty to account in respect of this 2.4 million before it is transferred into what is called his Pitman and Cold Star accounts? Well, it's certainly not suggested that there is any such duty, and indeed that's not surprising. An allegation to that effect would be positively inconsistent with the way the case has been pleaded in 19. If it were the claimant's case that the 12 million was already held by the defendant for them, whether on a trust or in a fiduciary capacity, then this payment in 1996 to 1997 would not have changed anything. And it certainly wouldn't have resulted in the engendering of a fresh duty to account. The only way this makes sense is on the basis that these monies, which are alleged to be sitting in the B, Kidney and or Tyson account, are out with the scope of any duty to account on the part of the defendant until the transfer is made. And again, that's perfectly consistent. That's actually consistent with the way the claimants put their case. It's also, as we'll see, consistent with the evidence before the judge.
I'm sorry, I'm missing something.
Of course, my lord.
Paragraph 19 starts by saying, between 96 and 97,
Yes.
the claimants jointly transferred to the defendants various sums of money,
Yes.
totaling approximately in excess of 8 million, namely 12 million, 2.4 of which belong to them.
Yes.
And your point is that that is inconsistent with the prior existence of a fiduciary obligation?
My point is simply this, which is that the allegation is that that money is said to have been added to the trust fund. It's become part of what Mr. Jassat is holding for the defendants when these payments are made in 96, 97. That is the pleaded allegation. So ask yourself, is it being said here that if and to the extent this money was in B, Kidney and or Tyson in 1995, or indeed at any point between 1989 and 1995, is it being said that there is a duty to account in respect of that money? No. A fundamentally different case is being advanced, which is this money is sitting in B, Kidney and or Tyson. What we do is we pay it to you, Mr. Jassat, in 1996 or 1997, and when we do, it is property that is added to the trust fund. That's the logic of this case. My lord, if we go over the page to paragraph 20, paragraph 20 refers to...
Hold on a second.
Sorry, my lord.
I'm being very slow. So you say that the 4 million in 1982, see paragraph 14.
Yeah.
And then the 12/2.4 million doesn't become of interest until paragraph 19. It's transferred from the Kidney or Tyson accounts into the Cold Star or Pittman account.
Yes, exactly. Because that's the way it's pleaded. What is said is we gave you 4 million, and then we gave you another 2.4 million. And we did it by transferring, in a date, we're not sure exact, 96 or 97, we're not sure, but we did it by transferring money from our accounts to your accounts.
Right. Okay. Well, I think I'm with you so far.
Yeah. Please do let me know if I'm...
No, if you're going too fast for me, I will tell you.
well, going too fast or being insufficiently clear. My lord, if we go now to paragraph 20 of the particulars of claim, there you have the identification of a document which is said to support the fact that this payment was made. This is a document, this is a reconciliation of funds that was attached to Mr. Seether's statement. I mean, it doesn't actually matter in passing, it actually doesn't show that money being paid to, from particular accounts to particular accounts, but it does seem to suggest that that amount at approximately 12 million was, as it were, extant as at May 1997. And then, my lord, if we go forward to paragraph 21, which is on page 102, and this says, as a result, in or around 12th of November 1991, the defendant purchased various properties with the consent of the claimant as outlined in a document entitled the Richmond Lodge Document. These included the following properties which were purchased by the defendant with the claimant's monies on a date unknown to the claimants, but with the claimant's express oral consent. So, my lord, this is pleading that certain properties were purchased with the claimant's monies in or around 1991 and with their consent as a result of what has been stated above. That's the opening wording of the paragraph. So what this paragraph is purporting to do is identify properties that have been purchased with, as it were, the trust fund. And I'm using that in a loose, I know the judge rejected it, but it's a helpful nomenclature. So this is saying Mr. Jassat has purchased properties with the trust fund. Now, given that this is 1991, that can only be a reference to the 4 million. Because the 4 million's paid, the 4 million's actually said to be paid in 1982, and then nothing more is said to be paid until 1996, 1997. And then if you go forward to page 104, paragraph 22, this paragraph rather confirms the point I've just been making. It says, it is averred that the aforementioned properties were purchased using the claimant's monies held either in the Camelot account or the Cold Star and or Pitman accounts, or from a named account containing the claimant's monies, the details of which lie within the defendant's own knowledge. So what it's saying is money comes from Camelot, Cold Star and or Pitman, which is broadly, there's a slight chronological issue, but that's broadly consistent with what has been said above. And then there's this reference.
Chronological issue, have I got this right, is that Cold Star and Pitman is only referred to above in 1996.
Exactly, that's the...
So if you're going to be super analytical about this, this suggests that in fact some of the properties may have been bought after 1991, 92.
Well, that may be right, my lord, and that doesn't matter for present purposes. That may well be right.
Good.
But
and that you're making some big point about, or a point.
No, I was making
that 1991 could only be the original 4 million.
Yes, I mentioned that in passing. It's not a critical point. The point I'm trying to track through how this trust fund is accumulated and then used. If that makes sense. But I think your lordship's probably right about that. That what makes the most sense is that, particularly given that the claimant's knowledge about some of these transactions seems to be limited, that they are fairly in the circumstances saying, well, it could be from the 4 million, it could be from the 2.4. They're not saying that expressly, but that's certainly a fair reading, and I don't take any point against them on that.
Thank you.
Now, in 22, there's no suggestion that payment was made from, for example, the B Kidney or Tyson accounts. And actually, for reasons I've mentioned a couple of minutes ago, that suggestion wouldn't really have made sense, given how the pleading has proceeded thus far, because what is being said is B Kidney and Tyson are our accounts, and what we do is we pay that money to one of your accounts in order to give you control over it, and then you invest it. Now, my lords, there then comes quite a lengthy section of the particulars that I can deal with more briefly. You will doubtless be relieved to hear. Because they don't really change the position fundamentally. So 23 identifies various properties which the claimants know Mr. Jassat has bought and which they say might or might not have been bought using what I've identified as the trust fund. Then paragraph 24 says where properties were purchased using claimants' monies, they were expressly confirmed by the defendant to the claimants as an addition to the trust fund. So again, that's part of the investment of the monies that have been placed. 25 refers to various sub-trusts, which is not really relevant for present purposes, but is effectively a piece of evidence. Over to page 106, paragraph 26 contains an allegation of failure to account in respect of those sub-trusts. At the bottom of that page, 27 comes up with various alternative legal characterizations of the facts pleaded, but it then doesn't change the guts of those facts. 28, starting on page 107, is a very lengthy paragraph that starts, in support of the aforementioned claims, the claimants rely on the following evidence. Of course, one short point is that's another way of saying, here's a paragraph that shouldn't be in the particulars of claim at all. But in any event, it is material in support of that which has been alleged above. That takes you all the way through to page 113. Paragraph 29, it's alleged that the defendant holds the properties and all the monies referred to in the Richmond Lodge Management document jointly and on trust for claimants. Now, yes, that is alleged. The basis for that allegation, the factual basis for it, is that which has been pleaded above. And in effect, what the Richmond Lodge document is relied upon throughout this, perhaps understandably, given what it says, is as evidence of the substantive relationships pleaded in the particulars of claim. 30 is about oral demands for repayment of the monies. 31 and following, paragraphs 31 and 32 to 33, are all about alleged breach of duty. But again, the breaches flow from that which has been, are said to flow from that which has been alleged above. Paragraph 34 at page 115 identifies a different basis for liability, which is a claim for specific performance of what is called the 1982 agreement. And then, doubtless with something of a sigh of relief, one comes back to 35, which is where I started, which is the breach of fiduciary duty claim.
Could you just help me? Paragraph 34,
Yes.
line 5.
Yes.
There should be word document after lodge, shouldn't there?
Yes.
So once again, what they're saying is that what is referred to in the Richmond Lodge document is properties or assets acquired with our money.
Yes, they're saying that that's what the document says. Yes.
They're actually saying that that is what happened.
But that's slightly tricky because as earlier in the particular claim I've shown you, their position is we don't actually know exactly what he's done with our money.
They are asserting not merely that the Lodge document says this, but that the investments and joint property portfolio is a portfolio which he admits holding for the claimants. So this is not simply an assertion there's a document, it's an assertion that these are investments
held for
purchased
us
with their money.
Yes, they do say that. They say that the property in the Richmond Lodge document represents the proceeds of their money.
Yep.
But of course, again, that is subject to the case they have pleaded as to their money. Because what they've done is they have pleaded a case as to a trust fund being set up in a particular way and funded in a particular way. I would also point out, my lord, that one should be careful about sort of basing too much of everything on 34, because that paragraph is actually purporting to quantify a claim for contractual damages by reference to the Richmond Lodge document.
Yes, but I just wanted to be sure what I understood what
Yes.
you were saying
My lord,
about the status of, or the reasons why there are references to the Richmond Lodge document.
my lord, I should also say, it's perhaps worth pointing, it's a point I will come back to. The pleaded case is that actually the Richmond Lodge document is inaccurate. And it is perhaps worth just having a quick look at that. My lord, if you go to page... Sorry, we have to go back a bit. I should have perhaps made this point earlier. If you go back to page 107... And it's at the bottom, you'll see it's paragraph 28, the evidential paragraph, starts at 1 talking about the Richmond Lodge document. And then over the page at 108, if you go 8 lines down, you'll say, it describes the Richmond Lodge document. And then it says, these sums exclude the 4 million that had been expatriated prior to 1982, which have been omitted by the defendant in the Richmond Lodge document. If you then go forward to page 116, paragraph 37.3. Now this is actually slightly ahead of where we just got to. These are the allegations of breach of fiduciary duty. So in breach of fiduciary duty, the defendant has, and then go down a bit, sub 3, failed to keep full and accurate records in that the Richmond Lodge document does not provide a sufficient account of the defendant's dealings with the aforementioned trust, nor does it provide full details regarding the properties described therein.
So when you describe it as inaccurate, what you mean is it is not a complete record.
Yes, but what is being said, the logic of what is being said, is that we have created a trust fund, which we have given to Mr. Jassat. He has invested it, and the Richmond Lodge document represents an incomplete statement of the proceeds of that investment. That is the logic of this case.
But that includes an allegation that everything that is on the Richmond Lodge document is admittedly held by the defendant for the claimant.
Well, it says what it includes is a finding that...
No, not a finding, an
sorry,
allegation.
Sorry, my lord. Yeah.
These are allegations. The allegations are, you gave us this document, that was intended to be an account. It's not complete, because you didn't put everything on it, but what you did put on it, you admit holding for us. That's what they're saying.
Yes, that's what they're saying. But what they're also saying in substance is that is the proceeds of investment or some of the proceeds of investment of the money that they have placed, of what I call the trust fund. That's the logic of it. And indeed that's express, because they... Sorry, I managed to turn to a different page. Just give me 1 second, my lord. I'll need to pick up the reference, but they say in here that the Richmond Lodge document is produced as a statement of effectively what has been done with the trust fund.
Yep.
So, my lord, the end point of that analysis is what I have said in my appeal skeleton, namely that the pleaded case on property being placed with the defendant, such that he received it in an accountable capacity, is actually limited on the face of the pleading to A, the 4 million said to be placed with him prior to 1982, and the 2.4 million said to be placed with him in 1996, 1997. Now, there's an important point here. It's the point I make at paragraph 11 of my appeal skeleton. The claimants could have alleged that Mr. Jassat owed them a duty to account, generally in respect of, as it were, all of their share of the expatriated monies, as soon as they hit Switzerland. We know from the limited Sars documentation that what was being said to Sars is that the total expatriated is roughly 200 million. That they're claiming that...
Rand.
200 million rand, that they are entitled, or claim to be entitled to 20% of that, so it's 40 million rand. And they could have said, that money hits Switzerland, the Swiss accounts are under Mr. Jassat's control, and he owes them a duty to account in relation to that money generally. However, for whatever reason, that is not their case. The case is more specific. Now, we don't really need to conjecture as to why that might be the case, but there are any number of possible reasons for it. But that is the case. And I should say, my lord, that was made clear to the judge in a variety of different ways. And it is perhaps worth looking at this a minute. I want to start with the list of issues for trial. Which is supplemental tab 1, and I want to go to page 7.
Sorry, Chief, could you give me the reference again?
Yes, of course. Supplemental tab 1, page 7.
Thank you.
And these are the issues that were before the judge for the purposes of the trial. And just a couple of quick points. You'll see the 4 million is dealt with at paragraphs 3 and 4 on this page. So was 4 million expatriated prior to 1982, and what became of that money, which of course encompasses the allegation that it was paid to Mr. Jassat. Then at 4, what was the claimant's interest in that money? Then if you go over the page to page 8, at paragraph 9, it says, in relation to the amounts of money allegedly transferred to the defendant in 1996, 1997, the amount of money which was transferred to the defendant and the nature and scope of and basis for the claimant's interest in any part of that money. And then, my lords, just quickly to round this point off, it's perhaps worth going to paragraph 26, which is page 11, heads of putative liability. It said, in light of the conclusions reached above, and then at 2, whether the defendant held any particular monies in whatever form paid to him by or at the direction of the claimants on trust for them or either of them. So that, as it were, follows on from the 4 million and the 2.4 and picks up the way the case has been pleaded as I've explained it. 26.3, whether there's a breach of trust, and then 26.4, whether the defendant is in principle liable to account in equity to the claimants or either of them in respect of the monies identified in 26.2 above and all the traceable proceeds thereof. So that's the going right back to the beginning. That's the way it was framed in the list of issues.
Can you just help me?
Yes, of course.
Where this document refers to the expatriated monies,
Yes.
that's a reference to all the monies that were expatriated.
Yes.
So when 24 says whether and to what extent the defendant is a trustee for the claimants or either of them in respect of the expatriated monies or any part thereof,
24.
that is not limited to the 2.4 and 4 million. Top of the page.
Yes, I think. Can I just double check? Yes, my lord. I think that's right. Certainly, as regards trusteeship, yes. My lord, if I could then go forward to the way it was put to the judge. So it starts at 60. I want to go to paragraph 63 of my written opening, which is supplemental tab 11, page 229. And, my lord, 63, you'll see impact on the claimant's pleaded case. You'll see C's pleaded case in relation to when and in what amounts their alleged share of the expatriated funds were placed at D's disposal is limited to the following three allegations. First, that they placed 4 million with him prior to 1982. Second, the loan of 1 million, which has fallen away. Third, the payment of 12 million in 96-97, of which 2.4 million was said to be theirs. My lord, perhaps it may not matter, but the context of this is that before that Sars letter was produced on the second morning of trial, there was an issue as to whether, on one reading of the settlement agreement, it suggested that the total value of the expatriated funds wasn't 200 million, it was much, much less than that, because the schedule refers to expatriated funds in a sum of, I think, about 20 million rand. And so, and that was what the judge was giving the claimants a hard time about on the first day of trial that led to the production of the Sars letter, which gave the tax calculation and, as it were, got you back to the 200 million. But in any event...
What was a rand worth for these purposes?
Well, the problem is, that rather depends when you're asking the question, because the period is so long. So I think... my lord,
But how does the 200 million rand compute with the 12 million and the $4 million?
So if you assume that so the point is this, which is that if you assume it's 200 million, and so that's 40 million rand for the claimants. I think the answer is it works just about, if that makes sense. It wasn't
works just about
in terms of the money being said to pay. The money said to have been paid to Mr. Jassat is not actually greater than the amount of the expatriated money. Does that make sense, my lord? Because on the basis of the settlement agreement, it looked like the figure might have been said to be much lower than 200 million, and that created really fundamental problems. It's an analysis I conduct in some detail in this section of my opening, but as I say, it rather fell away because of the Sars letter produced on the second day of trial, which did, being realistic, make it look as though the figure in the Sars settlement, which did say expatriated monies, actually wasn't expatriated monies, it was the tax payable on the expatriated monies. So the gross figure
was at a rate of 45%.
I think it was 25%. But I don't remember the exact figure, but anyway, my lord,
You grossed it up.
It had to be grossed up, and that gave you a higher figure for expatriated money, which meant that the pleaded case I've just taken you through, the 4 million and the 2.4 million, was no longer hopelessly inconsistent with the case as to the total amount of expatriated monies. Sorry, I've gone through that quite summary
Yes.
form. I hope that makes...
While we're looking at this, picking up a point my Lord made earlier, the list of issues for trial and liability starts by saying on page 7 that abbreviations
Yeah.
used in the amended defence are adopted, and there's a definition of expatriated monies in your amended defence,
Yes.
which is monies said to have been generated by a South African business and illegally expatriated to Switzerland.
Yes.
So it's not confined to any particular monies. It's just a global reference to.
I think that's right, my lord. When we say expatriated monies, that is, well, it's what it says on the tin. It's the expatriated monies generally. I think
Yes, but it's not this sum and that sum and that sum. It is monies said to have been expatriated
and the
by these individuals out of South Africa.
And the logic, my lord, is that it has to proceed in stages, because the first question is, well, what is the amount of the expatriated monies, and did the claimants have any interest in any of it? Because if you fall at that stage, obviously what subsequently happens falls, and then you have to look at what they've alleged to work out whether their breach of fiduciary duty claim works. And that is what I am coming to. My lords, I was now going to turn to the judge's reasoning and why we say it's wrong. And what we say is that if you were to take the claimant's case on breach of fiduciary duty, applying the legal test that I took you to earlier, as it were, at its highest, the proper scope of the account and the duty to account would be in respect of the two sums that were said to be put, and the only two sums that were said to be put into the trust fund, namely the 4 million and the 2.4 million. So now one asks oneself, well, what did the judge actually do? So I want to start, if I may, at paragraph 120 of the judgment, which is at core tab 5, page 84. And what the judge says is the defendant has control of the claimant's monies and the investments made from those monies, but is non-specific as to what those monies and investments are. Then 121 deals with our case that that Mr. Jassat's only liability to account was to Mr. Hatharani. And then if you go over the page at 122, finds there's been a breach of trust in relation to, a breach of fiduciary duty in relation to the transfer of assets to what was called the Richmond Trust. And then at 123, there's the judge's finding that, or conclusion, that the account should be defined by reference to the Richmond Lodge Document. Now, well, as we say the following about these conclusions. On the judge's legal analysis, the touchstone for liability, or certainly the starting point for liability for breach of fiduciary duty, was the claimant's placing property under Mr. Jassat's control such that he received that property in an accountable capacity. So the first question is, what property? And in my submission, the judge didn't answer that question, and almost seems to have thought that he couldn't answer that question. And I say that, my lord, because of what he said again in his reasons for refusing permission to appeal. So it's back to tab 6, page 87 in the core bundle. And he says at ground 4, this was about our complaint about the findings in relation to the Richmond Lodge document. The veracity of the document was a central issue at the trial. We will come back to that. The court has to decide the nature and scope of the account to be directed. Well, that's unquestionably right. The court does have to do that. But it's very easy to do that. If the foundation of liability is an Aldwason type claim for breach of fiduciary duty, if the touchstone of liability is the placement of property under the fiduciary's control, then you simply direct an account of dealings with that property. It really is very simple. There is no need to do anything more than that. And so when the judge says the court has to do something, one almost gets the impression that the Richmond Lodge document is being treated as it were any port in a storm. And that's just wrong, because as I've shown your lordships, the pleaded case is very clear. If you were to ask, what do the claimants say was the property placed with Mr. Jassat and received by him in an accountable capacity? It's the 4 million and the 2.4 million.
Well, does it come to this, that this is really a pleading point, that the only assets which the claimants allege they gave to Mr. Jassat were those two sums?
Yes.
But I wonder if, when you say the pleading is very clear, I have to say it doesn't seem to me to be a model pleading, but I wonder if that's really a fair construction of the pleading. I'm looking at paragraph 19.
Yes, my lord.
So 19 starts off by referring, and it suffers from the fact that it's been amended. But originally, it said the claimants transferred to the defendants various sums of money in excess of 8 million. And then it's particularised by amendment. It's 12 million, and 2.4 of that is ours, which is 20%.
Yep.
And then there's a reference to the 2.4 million. But then, towards the bottom of that page, page 99, there's a sentence starting, moreover, and then we get the Richmond Lodge document. Now, it's reading quite a lot into the word moreover, but that could mean, in addition to the 12 million we've already talked about, we now have other evidence of our property which has found its way into Mr. Jassat's hands. Look at the Richmond Lodge document. You can see their reference to the 12 million, 2.4 million of which belongs to the claimant. But it also includes an admission of a joint investment and property portfolio to the order of at least 9.6 million. Now, it's quite difficult to say that that allegation, when there's a cross-reference to 28.1 below, where they go into that in a great deal more detail. It's quite difficult to say that taking that paragraph as a whole, it's intended to allege the only money we've given you is 2.4 million.
Well, I think the problem, and it is a problem with the amended particulars of claim, although it's not a problem that can therefore be held against me, is that there is a constant elision of two different things. What is the trust fund and what was done with it? Because, of course, those are two different things. Remember, the Richmond Lodge document is produced, nearly 20 years after the fact. So one needs to be quite careful, I think, about keeping those two separate. What is the trust fund? What is the property in relation to which the liability to account arose? And then a separate question, which is, well, where has that money ended up? And the Richmond Lodge document may be important evidence in that process. But what I say is that it's really very difficult to read the pleading as saying that there is money placed with Mr. Jassat other than that which I've identified. And I mean, the question then is, well, how does this duty to account arise and when?
Well, if you look at page 108 of the bundle, page
Yes.
18 of the pleading, so this is paragraph 28, which is cross-referenced in the amended paragraph 19. The last sentence in the main paragraph says, as at 31st March 2008, the Richmond Lodge document comprises a joint property and investment portfolio belonging to the claimants.
Yeah.
Well, as I say, may not be particularly well pleaded, but why is that not an allegation? That the one thing we can aver, even if we can't tell you quite where it came from, is that at that date you held this property portfolio, it belonged to us, therefore you're accountable for it. Well, what's wrong with...
Well, what's odd about that, my lord, is, as I say, it's an extraordinary circuitous way to reach a conclusion that is, well, at least in this respect, because what has happened is that money goes into Switzerland. As I say, they could very easily have pleaded. X amount of money went into Switzerland, 20% of it is ours, and Mr. Jassat has to account for that 20% generally. And in that context, we say that the Richmond Lodge document tells you where that money ended up. The issue is this, which is that the judge has found their claim. I mean, first of all, this reference to the money being property of the claimants being held on trust for them, of course, technically that has actually been rejected, that allegation. What the judge has found is that there is a claim, a good claim for breach of fiduciary duty on a particular basis. And the particular basis is that the principal places money with the fiduciary, places his money or his property with the fiduciary and the fiduciary receives it in an accountable capacity. Now that simply doesn't work in relation to the Richmond Lodge document considered in isolation, because the claimant's case is that is the proceeds of things unknown that Mr. Jassat has done with their money. Now,
I'm very sorry, Mr. Peters. I'm obviously being very slow. My Lord has taken you to the passage on page 108.
Yes.
But if you look at the start of paragraph 28(1),
Yes.
at the bottom of page 107, the Richmond Lodge document, in and around 2008-2009, in acknowledgement of the monies and properties the defendant held on trust for the claimants, the defendant provided the claimants with the Richmond Lodge document. And then you have the passage which my Lord took you to. I may be seeing things far too simply, but I would have thought that that is an averment, that the Richmond Lodge document sets out monies and or proceeds of monies which have been converted into properties, as at the page 208/2009. And what the judge has said is, so far as the properties are concerned at any rate, that's the starting point.
Well, my lord, can I can see that. My answer to it is...
What am I missing, or what am I...
Well, can I at least suggest what you might be missing? You may not agree with me, my lord. First of all, you've got to look at the opening words of paragraph 28. Paragraph 28 says, in support of the aforementioned claims, the claimants rely on the following evidence. So everything that follows is put forward expressly on the basis that it is evidence in support of the claims pleaded above. So it would be very peculiar if one could use that to sort of reverse engineer a head of claim that is not.
But you've got the time differential. You've got the dates when the payments were made, which were in the early 90s. And this is saying, by the time you get to 2008, 2009, there's been other developments, things have happened, and the Richmond Lodge sets it out. What's wrong with that?
Well, I think the danger is that one risks, again, eliding two questions. One is, what is the basis for liability, and is it made out, and does it work as a matter of analysis?
But
because there you do have... Sorry, my lord.
No, go on.
There you do have to go back to the initial stage. There is then, as it were, almost like a case management pragmatic question, which is to what extent does the Richmond Lodge document, when one is assessing quantum, allow one effectively to cheat?
That's a separate question. But we'll go back to a judgment. Paragraph 96 is a finding of fact. I find two copies of the Richmond Lodge document intended to be a statement of account of the assets under the defendant's control, which were derived from the claimant's money. Now, I haven't understood whether your case is that wasn't open to him on the pleadings to make that finding, or it wasn't open to him on the evidence to make that finding, or even though it's open to him to make that finding, a duty to account doesn't follow. Because I have to say, the third step, if he was entitled to make that finding, I would have thought it's not difficult to find that a duty to account follows. So which is it? Is it it's not pleaded, or there wasn't evidence, or the conclusion doesn't follow? Or is it something else? I may have misunderstood. I'm sorry.
Let me do my best with it, and perhaps your lordship will tell me if I've satisfactorily answered your question. So, what the judge finds is that when Mr. Jassat handed over the Richmond Lodge document, that was intended by him to be a statement of account. Okay, well, fine. The first thing is, that doesn't actually answer the question of what the because Mr. Jassat is most obviously not a lawyer.
Where did it come from?
Exactly. Where does
his finding is it's derived from the claimant's monies. He doesn't need there, and doesn't, I think, identify which payment on what date, because he doesn't have that evidence.
but-
I mean, this goes back to something I said before, which is that people have not assisted him, as they are obliged to do in litigation, by telling the truth and giving him the documents. So he's having to make the best of what he's got, but he makes this finding that it's intended to be an account of what is derived from the claimant's monies. He doesn't then need to say it comes from a 2.4 million paid on the 30th of April 1996, and it comes from the 4 million paid to a different account in 1982. He doesn't need to make those findings. If he makes that finding, that's enough to generate a duty to account, isn't it?
Well, except it's what he's making a finding here as to Mr. Jassat's intentions.
Yes, but I mean, but that's because there's a dispute as to what were the circumstances in which this document was generated.
But that matters, my lord.
But if he finds, well, it's not very difficult to then infer that then it's an admission against interest, and that was an accurate statement, if incomplete, of at least some of the assets derived from the claimant's money.
But I have difficulty with that, my lord, because I do say that, and here we trespass. There is an interconnection between ground 2 and ground 3. Because
I understand that.
what we say is that there's a finding as to what Mr. Jassat intended the Richmond Lodge document to be, and that is what the debate was at trial. The debate was it proffered on one basis or another. But of course, simply answering the question in that way begs a more fundamental question, which is, was Mr. Jassat right? And it's interesting. This is pleaded, this Richmond Lodge document, as evidence of monies held on trust. Now, of course, the judge's findings is that no monies have been held on trust at all. What one has to do in my submission is look at what the basis for liability actually is, establish whether it works, and if it does, then the Richmond Lodge document may provide either useful evidence or even a shortcut as to what the statement of account is. But one does have to go back and analyse and say, does the duty to account actually arise in the manner found by the judge on the pleadings and the evidence? Does it all work? Because if the judge's earlier conclusion, and it does come earlier, there was a point at which a duty to account arose. And if it did, then as it were, one can look at subsequent information to work out what the state of account might be.
Why do you need to investigate the archaeology of when the duty of account arose? If you have an individual who says, I agree, I'm holding this money for you on a particular date, how he got to that position, where the money came from, which particular transfers funded it, seemed to me to be irrelevant. You have an admission that on a particular date I'm holding a property for you. That generates a duty to account thereafter to what you do with it.
Well, then it is saying that actually, what then is one is doing is elevating one is saying that the admission is actually the sole and sufficient legal source of the duty to account.
What's wrong? If I say to you, Mr. Peters, you may not remember this, but at some point in the distant past, I agreed to hold some money for you, and I can tell you, I now have £153 sitting in a bank account, which is yours. That's an admission. It doesn't matter how it came about that I've got £153 of yours. I've accepted I have. Now, of course, an admission is not absolute proof, because sometimes admissions that can be explained away. But in this case, the judge finds not only that it was intended to be a statement of account, but it was an acknowledgement that your client was holding the properties for the claimants. He finds that at paragraph 123. The Richmond Lodge document, in my judgment, is an acknowledgement by the defendant of a state of account as between the claimants and the defendant. What's wrong with that finding?
Well, my lord, I think there are, and here we do, I think, trespass into ground 3. There are several things we say wrong with that finding. First of all, it doesn't fairly reflect the way the case has been pleaded. And I've taken you through the pleadings. And my submission about the pleadings...
But is this really a pleading point?
Well, it is in part, and I think it's also... It raises difficult questions about where that leaves great swathes of the judge's analysis, because the judge has purported to analyse this, as it were, in accordance with the law that he found at paragraph 118, I think it is.
Yeah.
So he's gone through the steps. He's talked about property of the claimants put at the disposal of Mr. Jassat, his control. Now, the problem is that if one is reading the judgment as saying actually what the judge has done is found that the Richmond Lodge document carries all before it, that's a very different analysis. I mean, on that view, great swathes of what the judge has said are irrelevant, because, my lord, putting it the way that the stark way that your lordship did, the judgment could be significantly shorter, because the judgment could be a finding about the Richmond Lodge document, and then I need go no further.
But he makes clear in the judgment that he's got a number of strands which he considers as supportive. We haven't looked at them in detail, but for example, he finds some support in the Grant Thornton document. He finds some support in the emails. They're not rendered irrelevant by his finding. They contribute to his finding about the RDO.
Well, I think that, well, my understanding of the judgment, and it may be that I have misunderstood it, is that the judge makes various findings on, as it were, the evidence, including in relation to the Richmond Lodge document. Those justify the conclusion he reaches at 120, which is money has been placed under Mr. Jassat's control, and by money of the claimants has been placed under Mr. Jassat's control, and by virtue of that, he is liable to account as a fiduciary in accordance with Al-Dwayson.
Yeah.
So that's the logic. I make various findings on the evidence, including the Richmond Lodge document, and then I establish liability by reference to an Al-Dwayson type fiduciary duty, which is dependent on money being placed with the defendant. He then goes a step further in relation to the Richmond Lodge document and says, and actually I'm going to treat that as a statement of account.
I've just been looking at the claimant's written opening for
Yeah.
trial in the context of your pleading point. And it looks as though the case was being put at the opening, I don't know what was said in closing, on the basis that the Richmond Lodge document recorded or confirmed that the cash and property portfolio held at the date of that document included the 4 million and the 2.4.
Yeah.
But wasn't necessarily limited to that. In other words, at the start of the trial, the case was being put on your analysis, went outside the parameters of the pleading case.
Well, and that's why what we said, that's why we put the case to the judge, as I've shown you, very much on the basis that this is the property that is placed with the claimants. Now, one thing that is slightly...
if that's right, then you could have complained, and maybe you did, that this was outside the scope of the pleading case, and it was all unfair, and if they wanted to put their case in a different way, they should amend, and you would resist it, and so forth. Is that what happened? Or?
Well, no, I don't think, it may not have been put quite that starkly, but we did say very clearly, and I've shown the court, we did say very clearly, look, your case on the property you've given us is the 2 million, and the 2.4 and the 4, and that means the court has to ask itself whether you can establish a viable claim in relation to those sums, because what you are talking about and what you are conflating is the money you have placed with my client and his duty to account in relation to that money with the end point.
So you accept that there was a transfer of the 2.4 and the 4 million into accounts over which he had control? Well, you accept that there is material upon which he could find?
I accept, just to be clear, I was going to come to this. I'm afraid this is only the first stage of my... I do have submissions to make about the 2.4 and the 4, but we've got rather caught up in a debate about whether the case is limited in that way. I mean, in very broad summary, and I'm going to come to this, I say in relation to the 2.4, actually the case doesn't work. Well, I say a number of things. First of all, there are real problems with the judge's analysis as to how the claimants were said to have an interest in this money at all. Which would be a knockout blow. If this was the claimant's property, then you say, well, does the claim work on an Alduason type basis? And in relation to the 2.4, I say actually on the evidence, the judge wasn't entitled to conclude that this was a payment by the claimants to the defendant at all. Because actually the claimant said it wasn't. In relation to the 4 million in the Camelot account, the position is different because that was an account that was actually the claimant's account. And they say they had control over it, and they actually admitted undertaking transactions themselves. So I make a different point, or an additional point in relation to the Camelot account, which is, well, what do the claimants need to come to court being able to say? Because the point about the Camelot account, my lords, is if I give you, if I give you a power of attorney over my bank account, and I conduct transactions and you conduct transactions, I can come to court and complain about your transactions on the account. But I do say I can't come to court and say, look, I want you to give me an account, both of your transactions on my account and my transactions on my account, because I can't remember what I did with my account, and I've deliberately destroyed the documents that would enable me to find out what I did on my account. I'm sorry, that's a very potted summary of submissions that I'm coming to. My lords, I was just going now to press on, if that's all right, with my submissions, because obviously we've had quite a long debate about that particular point. But I do say that on a proper reading of the pleading, what is said is it's the 2 million and it's the 2.4 million and the 4 million, rather than the other way around, and that the Richmond Lodge document stands as evidence of what may have become of those monies. And I say that if I'm right about that, then the judge's analysis falls at a first hurdle, because what he should have said is, well, what property am I talking about here? And he should have said it's the 2.4 million and the 4 million, and he didn't. Well, there's the next step, and the one that I adverted to a moment ago.
So, I'm very sorry.
Yes.
If the judge had been entitled to say it's 2.4 and 4 million received in those dates, he would then have ordered an account to see what had become or what
of those
had been
monies
made of those. Okay, but instead, what he's done is he's accepted that the RDL gives a statement as at 2008, 2009, and he's taken that as a starting point.
Yes, and I'm going to come to that in ground.
So you may be lucky, because you may have, if the RDL is incomplete, then you may get away with some monies which you should be accounting for.
Well, yeah, well, I can see that, my lord.
But at the moment, I don't see what's wrong in principle. If he finds, if he's entitled to find that, at least so far as it goes, the RDL gives an account of either cash or proceeds, why he shouldn't say, well, we'll take that as the starting point.
Well, but I think, again, that is jumping a step in my submission. It's jumping this step, which is he starts with the 4 and the 2.4. What you then have to analyse is, does a breach of fiduciary duty claim in respect of those monies work as a matter of legal analysis and on the evidence?
Because they were still sitting in your client's account, and he found that they came from the claimants.
This is
he would be entitled in some way. I don't know how you do it, but you would order that money be repaid.
My lord, there are various things I say about whether that case works. But the short point I'm making for the moment is, if it's the 4 and the 2.4, step 1, work out whether there is a viable breach of fiduciary duty claim in respect of those monies. If there isn't, claim dismissed. If there is, then there is essentially a pragmatic question, which is, how do you go about drawing the account? And that's where we get to my ground 3, which is that actually it wasn't appropriate for the judge to really be trespassing in that territory at all. But so I say it's the 4 and the 2.4. What I'm now coming to do is analyse further steps as to whether a claim in a breach of fiduciary claim in respect of those monies works as a matter of analysis. Because if it doesn't, then I say one has a real problem. Or rather, the claimants have a real problem. So in terms of the steps, as I said, the first step is, well, what's the property? And this argument proceeds on the basis that it's 4 and 2.4. The next step is it's property which has to be property of the claimants. Now, the judge analysed this question, whether it was property of the claimants, at paragraphs 53 to 56 of his judgment. Now, my lords, at trial, there was a debate about whether the claimants ever had any interest in the monies generated as a result of the off-the-book cash business, which was operated in South Africa. And indeed, the nature and extent of any such interest was specifically identified as an issue for trial and was an issue in relation to which extensive disclosure was ordered, although none was given. Now, there are points that I could make about that, as it were, threshold issue, any interest in the expatriated monies themselves, and I've trailed them at paragraphs 40.3 and 40.4 of my skeleton, which is core tab 10, pages 167 to 168. My lord, I can deal with that, and I'm happy to at a convenient moment, but my primary submission is that actually I don't really need to, because of what the judge said at the beginning of paragraph 56 of his judgment. So this is page 64 of the core bundle. So at 55, he deals with the position in relation to the off-the-books cash business. And what he does is he, as it were, refuses to find that, that the money actually belonged to the companies. So it's a sort of a negative finding. But that's explained by what he says at the beginning of 56, which is secondly, and in any event, I am not concerned with who owned the cash generated by the off-the-books business. That cash was given to middlemen, and no one in this case knows where it went. I am concerned with dealings with money standing to the credit of the account holders of various Swiss bank accounts. So what the judge is saying here is that actually one can, in effect, put from one's mind the question of any interest that the South African businessmen may or may not have had when the monies are in South Africa, when they're in transit, whatever that involved. What matters is what happens when they hit the Swiss accounts. So that's quite an important starting point, because it means that this is not, on the judge's analysis, a case in which the claimants are being said to have some pre-existing interest in these monies, which they are following into the Swiss accounts. The judge's analysis proceeds on the basis that there's something about the accounts themselves and the rights in relation to the accounts that is generating such an interest, that gives rise to such an interest. And so the critical question is, what is that something? What is it about the Swiss accounts that engenders a relevant interest that the claimants have in the money, or rather in the shows in action represented by the balance on the account? Now, my lords, I'm about to turn to the judge's analysis of that. Might I suggest, subject to your lordships, that might be a convenient moment?
Yep. Thank you very much. Well, we look forward to hearing what you have to say about that at 2 o'clock.
Thank you, my lord.
Thank you very much.
Yes.